Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone! In this update, we're going to look at a couple of cases in a moment, but first up, I thought, given how much the use of electronic signatures has been accelerated as a result, I think, of lots of remote working during the pandemic, I thought it would just be worth touching base with the whole concept of electronic signatures, particularly because we've had some updated guidance and updated practice note from the Law Society and the City of London Law Society. So that practice note was originally published in July 2016, and it sets out various principles to help determine whether contracts that have been entered into in a business context and executed using an electronic signature have in fact been validly executed under English law. So the practice note basically has been updated to reflect recent developments since 2016. Since then, we've had a Law Commission report on electronic execution of documents. We've had changes in practice adopted, particularly by the Land Registry and HMRC, and, like I say, increased use of e-signing platforms, particularly things like DocuSign, Adobe Sign, a practice, as I say, that was greatly accelerated, I think, during the COVID-19 pandemic, and which I think, no matter what happens with that kind of thing going forward, very much electronic signatures and the use of those kind of e-signing platforms, I think, is here to stay and probably is only going to increase. So the publication of the practice note, I think, acts as a bit of a timely reminder of the importance of complying with established legal principles when you're executing documents, whether they're being executed in wet ink or using more modern technology. So I think helpfully, if we sort of start at the beginning, the practice note does confirm that electronic signatures are valid for English law purposes. But whether a particular document has been validly executed using an e-signature will depend on whether the relevant legal principles have been followed in each case. Um, when we're talking about electronic signatures, the sort of types of electronic signatures that are identified in the practice note, all of which the note makes clear are valid, if you like, for legal purposes, are things like just typing a name into a contract, or pasting a picture of a signature into a document, or signatures generated by an e-signing platform, um, using an electronic copy of the signatory's signature, or things like signing a name on a touch screen, whether that's using a finger or a pen or a stylus, all of those kind of things which we're all beginning to get much more familiar with. The updated practice note confirms that where an e-signing platform is used to obtain signatures, then the existing principles on execution of documents at a virtual signing or closing must still be observed. So that means, in particular, it is important in relation to deeds that, for example, any signature and its attestation, the witness, forms part of the same physical document when the deed is signed, that the signed document is a discrete physical entity, and that the parties should sign an actual existing authoritative version of the document, even if they are doing that virtually via an e-signing platform. Actually, using an e-signing platform where the entire final version of the document is uploaded, in fact, makes it more straightforward, really, to comply with those requirements. There were concerns before around signatures being separated from the main part of the deed and that affecting the validity of the document. But like I say, with an e-signing platform, because you upload the whole version of the document, and then that is the thing that is signed via the platform, actually it makes it easier to comply with those particular requirements. One of the requirements for a deed, um, to be validly executed by an individual, is that the individual must sign it in the presence of a witness who attests that signature. So that's for an individual signing a deed. Actually, similarly, a company can execute a deed in various different ways, but one of those is a director signing on the company's behalf in the presence of a witness, where you've just got the signature of one director. Sorry, where you've got the signature of one director, that signature has to be witnessed. Now, the note confirms that to attest the signature, the witness has to be physically present, has to see the document being signed by the executing party, and then has to sign a statement in the document saying that it has been signed by the executing party in their presence as a witness. And usually that kind of wording is built into the execution block itself. But the updated practice note makes very clear that the witness has to be physically present when the signatory signs, and it's not acceptable for the witness to view the signing through some form of live video link, for example. So even if the document itself is being signed virtually using an e-signature, the witness must be physically present when the signatory applies their e-signature to the document and can't, for example, witness it over Zoom or something like that. So, like I say, regardless of what form of e-signature is being applied, the witness must be in the same room as the signatory, or at the very least, able to see the signatory through a window, which was a solution that people adopted um, during social distancing during the pandemic. Um, the question of the identity of the witness isn't actually specifically referred to in the updated practice note. Um, there are some rules about witnesses which can affect the validity of a deed, and in particular, one of the key ones is that a party to a deed can't act as a witness for another signatory to that same deed. So, for example, if you've got, let's say, husband and wife, two parties to the same document, they can't witness each other's signatures on that particular document. Um, Interestingly, perhaps, there's actually no statutory requirement for the witness to be independent. So if a spouse was signing a deed and the other spouse wasn't a party to that deed, in theory, the other spouse could act as the witness of the first spouse's signature. Um, I'm saying that that's okay. It is sort of legally okay, but you have to remember what's the purpose of the witness, and the purpose of the witness is to provide independent evidence about the validity of that signature. And obviously, somebody who is properly independent and unbiased is always going to have more credibility in a court. Um, than somebody, a witness who's closely related to the signatory. So I think if it's possible for your deed to be witnessed not by a family member, by somebody who is properly independent, then that would be preferable. But if there isn't any other available solution, then it is possible for somebody who is related to the signatory to act as a witness if there's no other option there. So that's a bit of an update on electronic signatures, largely confirming a lot of what we know, but some useful reminders there. The one about the witness being physically present is one that has tripped a few people up, I think. So do watch out for that one in particular. So let's move on now, and we'll have a look at a couple of cases for you. So the first one relates to an express duty of good faith. In this case, it was in a shareholders agreement. The case is called Compound Photonics, And the Court of Appeal gave quite a restrictive interpretation of an express duty of good faith that was owed by company shareholders under a shareholders agreement. Um, and in particular, when it gave its judgment, the court confirmed the importance of context when defining the precise scope of an express good faith obligation, and it rejected a kind of formulaic application of general principles that had been drawn from previous cases. So the facts in this case were that two minority shareholders of the company had been found to have suffered unfair prejudice, which resulted from the fact that they had been removed from office as directors of the company. So I'm going to refer to those two as the nominee directors. So one of those nominee directors had been sort of forced to resign, and then the other one had been removed by a resolution of the majority of the shareholders under the Companies Act. And at the heart of the High Court's decision initially was the finding that a shareholders agreement and the company's articles of association amounted to a constitutional settlement amongst the shareholders, and that the nominee directors were entrenched in office as directors. So if the majority voted in favour of removing them or sought to obtain control of the board, the court said that this would be a breach of contract. The Articles of Association included a provision which prevented the board from voting to remove the nominee directors. But importantly, the shareholders agreement did not include a comparable prohibition restricting how the majority shareholders could vote. So you've got a situation where the board are under a restriction that prevents them removing the directors, but the shareholders aren't under that kind of restriction. But what the shareholders had done, they had agreed in that shareholders agreement that they would at all times act in good faith in all dealings with each other in relation to the matters contained in the agreement. And the High Court, when it looked at this, said, well, that good faith clause could not be broader. And in particular, it required the shareholders to act with fidelity to the bargain that they had struck, i.e., that the nominee directors would remain in office. So the majority shareholders then appealed on the basis that basically they said that, well, the judges interpreted the good faith provision far too widely. So the Court of Appeal looked at this and they allowed the appeal, overturning the decision of the High Court. So here, what the Court of Appeal said was that they felt the Court of Appeal felt that the High Court judge had perhaps applied principles derived from previous cases a little too rigidly. And although concepts advanced in other cases could prove useful when interpreting a particular contract, actually it wasn't appropriate, the Court of Appeal said, to apply them in a formulaic way in every case. And a good faith clause in a contract was basically like any other contractual provision and had to be interpreted in the context in which it's used. So the court said that an express duty of good faith will consist of a core duty of honesty. And depending on the contractual context, it might also include a duty not to engage in conduct that could be characterized as bad faith, i.e., conduct that reasonable and honest people would regard as commercially unacceptable, but not necessarily dishonest. Any further obligation had to be capable of being derived by interpretation or implication from the actual contract itself. The court particularly referred to this concept of fidelity to the bargain as had been relied on by the High Court when it made its decision. Now, that was a concept that originated in the US and was then developed in New South Wales, in Australia, in the context of an implied duty of good faith. But here, the Court of Appeal said there was no legal basis for automatically incorporating that concept into an English law contract containing an express duty of good faith. And even where an obligation of fidelity to the bargain does exist, it should only operate in relation to the common purpose and aims of the parties as they could be objectively uh, ascertained from the terms of the contract. And as for the bargain that the shareholders had reached, well, the Court of Appeal did not consider that the shareholders had agreed that the nominee directors were to be entrenched in their positions. It said that, well, if the parties had intended to restrict the rights of the shareholders to vote to remove the directors, then particularly in a professionally drafted agreement, they would expect that the court would expect that to be expressed very clearly and directly. But the shareholders agreement in this case didn't contain any such express provision. So there, in English law, there is no general doctrine of good faith, but the parties to an agreement can expressly agree to act in good faith if they want. But if they do that, it's then going to be up to the courts to decide what those words actually mean. And that's what the court had to do in this case. Just saying that the parties will act in good faith of itself doesn't mean anything directly, and the court has to decide what it actually means in the particular circumstances. Um, so I think this decision does help a bit in that it says, well, actually, the exact scope and nature of an express duty of good faith will be wholly dependent on the particular facts and circumstances existing at the time. And there's no minimum standard which is going to be applicable to all good faith clauses. So, apart from importing a core duty of honesty, the parties really can't assume that a duty of good faith will impose any additional obligations. And so that I think that inherent uncertainty about how the duty might be interpreted by the court is going to be problematic for all the parties, although probably any uncertainty is going to favour the party that's having rights enforced against it, I think, because it will be able to argue against that particular interpretation. Um, so what should you do? Well, I think to mitigate against those uncertainties, really, you should, wherever possible, think actually about precisely what it is that you expect to do or not do, or you expect the other contracting party to do or not do when you're under that duty of good faith, and then actually talk about that expressly. So, in this context, if the nominee directors were interpreting that express duty of good faith as meaning our position as directors is entrenched and we cannot be removed as directors, then actually that should have been more expressly stated in the relevant documents. And you need to take particular care, I think, to explicitly note when parties are agreeing to give up their existing rights, such as voting rights or other decision making rights, or where the parties are expected to follow particular procedures in specific circumstances. So you're always going to be better stating specifically what it is you want people to do or not do, rather than relying on just some general wording about good faith. Okay, that's it for that one. And then finally, we've got another High Court decision, and this one relates to a buyer's warranty claim notice. There have been a number of cases about this over the years where, despite the sort of underlying basis of a buyer's claim for breach of warranty following an acquisition, even if that underlying claim itself has good merits, actually, if the buyer doesn't manage to get its notice of warranty claim correct in accordance with the provisions of the agreement, then it can't bring a claim or its claim fails. Like I say, even if actually underlying it has a perfectly valid claim. So in this one, the High Court refused to strike out a buyer's claim for breach of certain warranties in a share purchase agreement, even though the seller argued that actually the buyer's notice of claim failed to comply with the specific requirements of the particular agreement. So the facts in this case, it involved a £1 billion acquisition of a voice broking company. And the agreement in relation to the sale and purchase of that company contained various warranties from the seller, including that none of 8 named individuals were aware of any investigation against a director of the target group which would have a material adverse impact on the target's business. After completion, the buyer in fact discovered that a prosecutor in Frankfurt was actually carrying out an investigation into a director of the target. So the buyer sent notice of a warranty claim to the seller. The sale agreement said that the buyer's notice of warranty claim had to state in reasonable detail the nature of the claim and, if practicable, the amount being claimed. So the buyer discovers this claim by a Frankfurt prosecutor against a director. It thinks, okay, that's in breach of that warranty, that none of those directors are aware of none of them, there's no investigation against a director. And so it issues its notice of warranty claim. The seller receives that notice of warranty claim and then applies to the court to strike out the buyer's claim because the seller says the buyer's notice of claim was invalid. And it said it was invalid on 2 grounds. Firstly, it said, well, the buyer hasn't said in its notice of warranty claim which of the 8 named individuals had been aware of the investigation into the target's director. Remember, the warranty was that none of 8 named individuals were aware of an investigation. And the seller says, well, you haven't told me which of those individuals was aware of it, so your notice of claim is invalid. And then secondly, the seller said, well, the buyer has also failed to state that the investigation would have a material adverse impact on the target. Remember, what the warranty related to was investigations against a director of the target, which would have that kind of material adverse impact. And the seller said, well, because you haven't said that in your notice, you haven't said that it is going to have a material adverse impact, then your notice of warranty claim is invalid. But the court here disagreed with the seller and it refused to strike out the buyer's claim. So the judge reviewed the case law relating to these kind of unilateral notice provisions. And as I say, there have been a number of them over the years. And the court said, well, the construction and meaning of that kind of a notice has to be approached objectively. The issue is, how would a reasonable recipient understand the relevant notice? And where a clause expressly required a notice to state certain uh, required information, then that information must be included in order for a notice to be valid, even if it was actually something that the recipient already knew. You can't rely on that. If the notice has to state a fact, then you have to include it, even if you know that the other party already knew it. But in this case, we didn't actually have that kind of a clause. It didn't say exact information that the notice had to contain. It was much more widely drafted, simply requiring the buyer to state things in reasonable detail. And the judge said, well, in this case, what's reasonable is going to depend on all the relevant circumstances, and that would include what the seller, as the recipient of the notice, already knew. So, in relation to the sort of specific allegations that the seller made, the specific grounds on which it was trying to strike out the buyer's claim, well, the judge said that requiring the notice to state which individuals were aware of the investigation went beyond what was required by the specific clause in the agreement. That clause didn't say that those individuals had to be identified in the notice. The seller argued that the purpose of the requirements in the notification clause was to give the seller sufficient information to enable it to make appropriate inquiries, gather evidence, deal with the claim. But the judge said that including the names of the individuals didn't seem to add to the commercial certainty or purpose of the notification. So it wasn't necessary to say which of the individuals had been aware of the relevant investigation into the target's director. And then in relation to the impact of the notified claim on the target business, well, again, the judge said there was nothing in the notification clause that required the buyer to set this out in its notice. According to the judge, if you'd added that kind of statement, the buyer had said in its notice claim, we're aware of this investigation and it will have a material adverse impact. Well, the judge said, I don't really think that's going to add much. All you're going to be doing is repeating the text from the relevant clause. It doesn't advance any of the commercial purposes for giving the notice. So, as I say, this is the latest case really where a seller has sought to contest a buyer's claim for breach of warranty, not actually by disputing necessarily the merits of the claim itself, but instead by challenging the validity of the buyer's notice of that claim. And whilst the specific requirements of each clause will definitely turn on the interpretation of the words used, buyers are going to be well advised to include, I think, as much information as possible to avoid an otherwise valid claim failing on a technicality. This case was just a preliminary application by the seller to strike out the buyer's claim. And as the judge noted, whether the investigation complained of actually gave rise to a good claim and whether that claim was of sufficient worth and impact on the target were all matters that had to be determined at a trial of the claim's merits rather than being considered as part of the initial notification process and a challenge to that notice. So the judge is saying we need to look at that not on the basis of the notice and whether the notice is valid, but actually on the basis of whether the underlying warranty claim is sufficient. Okay, that's it for this month. Hope you found that interesting. I'll see you again next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.